All right, so I'm going to talk about software patent litigation, which we've had going on for 10, 20 years now. So we now have lots of data, which is great because while anecdotes are fun, they don't really tell us as much about what's going on as far as like broad strokes and general trends as the actual data does. So I'm not a lawyer. Are there lawyers in the audience? I'm always curious. Oh, everyone wants to see where the. All right, it's a lawyer-free zone. Okay, fantastic. There are some lawyers that are great. I'm sure I've met like four, maybe. They're fantastic. I'm gonna not answer that. So I'm not a lawyer. This is not legal advice. If I use a legal term that you're not familiar with, go ahead and ask a question. But if you want to tell me about your friend's lawsuit, don't do that because we're recording. Especially if your friend is your company and your boss is sitting behind you. So this is not legal advice. So not only am I not a lawyer, I'm particularly not your lawyer. So, but you know, it always helps to say these things so that people don't go and run off and make expensive decisions based on something that I'm giving you for background. So we'll start a little bit with the big picture of what's been going on. Some of this you're probably already familiar with, but it's kind of good to put the numbers on it. In 2014, the U.S. Patent and Trade Office granted 300,000 patents. They weren't all software patents. Depending on how you slice it, somewhere between 40 and 65% of them are probably software related in some fashion or another, or like hardware software combinations and that type of thing. So, and this is the most patents that have ever been granted, and it's also the highest rate of patent applications that were granted. So if you kind of go back like 10 years ago, the U.S. Patent Office would grant about 50% of the applications they received. But now in the past year, they granted 70% of the applications they received. There's a couple of reasons why this probably is. One is that the USPTO kind of works on commission. They get more fees if they grant the patents than if they don't. And I think they've gotten better at like, just cut clause 7, and then I can give it to you. So, you know, it's everyone in the whole process has gotten a little bit more savvy about how to make this work, where work means issue more patents. So you would think, looking at that, like, wow, that's so many inventions. What a place we live in. Like 300,000 new inventions last year. Like jetpacks. Like that doesn't even touch it. So unfortunately, most of those are not actually inventions. They're what we call, and lawyers will call this functional claiming. This is where you say, I have thought of a problem, and I'm totally going to fix it using software on a computer. And the U.S. Patent Office says, like, if you throw enough legalese on top of that, we'll totally give you a patent. I'm wildly paraphrasing. I do not work for the USPTO. So lest anyone think that is coming from the office. And so, you know, again, U.S. utility patents issued over time, they're not all software, again, but a lot of them are software. And so this goes up to 2013, and we know where it just keeps going. So this powers a lot of patent litigation. More patents, more litigation. A couple of things that we do know about those patents, about half of them were given to inventors from outside of the U.S. So sometimes I talk about this issue outside of the U.S., and I have to apologize profusely first for coming from the U.S. and being part of the exporting our ideas about IP law to other countries. But then it turns out that actually foreign inventors come over here and patent stuff in the U.S. Place. So it's kind of a weird thing that's happening. Speaking of like kind of more global trends. Like I said, we're sort of exporting, along with like Justin Bieber, our ideas about patenting. Oh, is he? I feel like, good Lord, why is he all over our news? Oh man. Okay. Sorry to all the believers in the audience. Is it a believer-free zone as well? Anyway, you can see that Australia has been issuing a lot of software-related patents. The EPO has been issuing a lot. Countries that have a pretty strict definition of what the scope of patentability is with regards to software come in much smaller. So Germany has, like, these are software hardware combination patents. You can see that a lot of the Asian countries have been doing a lot of work to catch up, and especially China has increased their patenting in the last like 10, 15 years, exponentially. So not only do we have a lot of software patents in the U.S., a lot of times those foreign inventors that I talked about will patent in their home district as well. So we've got patents all over. We also know that trolls are not only a uniquely U.S. problem. There's much less information on what's going on in Europe than there is in the U.S. But there is a great paper on what numbers there are, the numbers that are available, and we think that about 11% of the UK suits are software. Are trolls, and probably half or more of those are software. The reason the numbers are so fuzzy is that we know a lot of those suits get settled out of court. This is like kind of a favorite MO of non-practicing entities, is to send a letter that then agree to settle out of court. One condition of which is we will all never speak of this again. So kind of like the NSA does, right? So or they send you a letter and they're like, do what we told you, and then never speak of it again. In addition to like that 11% number, we also know that the line between practicing entities and non-practicing entities is getting a little bit fuzzy. So I talked about that at length last year, but this is still the case. We know that Microsoft has a bunch of patents, some of them they acquired through Nokia in the mobile space. They sold them to a troll called Conversant for $100 a pop, which is very cheap. That's like when you sell your friend a used car for $1 to avoid the taxes. And they're incorporated in Luxembourg and Ottawa and East Texas. So we know that suits are happening in other jurisdictions too, and letters are being issued and that kind of thing. One other thing that I thought was really interesting is that foreign inventors don't sue as often in the U.S., but when they do, they're more successful than U.S. inventors. No one really knows exactly why that is. It might have something to do with the accents. I'm not sure. A lot of Cumberbubble fans on the jury. Who knows? But so all of that said, like whether you win or you don't win, it still sucks to get sued because it's expensive and it's time consuming and all of these things that I'm sure everyone in the room is aware of, even if they don't have exact numbers attached to the amount of suck. So, yeah. So that's a thing that we're exporting in the U.S. What's that? Yes, lawsuits are a thing that we are exporting, and then bringing people over to come and see how it's done. So, so we're going to talk a little bit more about how it's done. And we don't have to apologize to the lawyers in the room because we already found out there aren't any. And there are a couple, like I said, a couple notable examples of free software lawyers that are fantastic, and then the rest, like, So, but we'll talk about the bottom feeders first. So, we know that about 65% of the NPE suits are software related. So, when we're talking about trolls, we're 2/3 of the time we're talking about software. I'm sorry. Trolls, like almost any other group, has a preferred term. They like to be called non-practicing entities as opposed to trolls. But we know what they are. Sending letters. Yeah, they're just sending letters. They're monetizing patents. They're protecting intellectual property on behalf of their clients. Yeah, exactly. So, right. Yeah, practicing challenged. So some of the other things that we know about trolls is they tend to litigate on the same patents over and over again, and sometimes they're more likely to litigate on a patent the minute it arrives in their office or under their purview. So And that happens one of two ways. Like they buy one from somebody else that's going out of business, and then they start suing on it immediately. So you look at the history of which patents are getting litigated on, and you'll see that it just very recently changed hands, just before it started getting litigated on. The other thing that you see is that brand new patents are also more frequently litigated. So you'll see a patent that gets issued, and then a week later, like the letters start going out. So that's another thing that we've been seeing happen. But then, like the overall age of patents that trolls use tends to get a little older because they keep beating that horse for like a long, long, long time. Yeah. The patent owner or or a representative of the patent owner is sending the letters. Yeah. So the lawsuits begin the minute they get the patent. Yeah. Or maybe on Monday or whatever. So, yeah. Another thing, so trolls, and we talk about that a lot. That's not the only problem, and the fuzzy line between practicing and non-practicing entities. Another thing that we've been seeing is that the lawyers that are bringing these suits have changed a bit. So, do people know what contingent fee representation is? Yeah, it's ambulance chasing basically, and that means and the reason we have this in the U.S. is that if somebody's done you wrong and you don't have any money to hire an attorney, the attorney can hire you can hire someone on contingency, and they just get a cut of whatever comes in. And so we've been seeing this happen more and more with software patent suits, where yeah. Okay. I'll definitely leave room for questions at the end. Okay. So so we've seen it with like large all the way down to small. So this is kind of a quote from an anonymous mid-sized company saying, even with a 40% contingency, they need at least $5 million in damages to break even. So they're taking suits on contingency, saying, why don't you let us monetize your patent? You'll get 60%, and we'll take 40%, and we'll bring 10 or 20 suits, and we expect to win half of them. So that means we need $5 million from each one that we win. And so, like, it's a whole play in the odds type of thing. Those are the larger companies that are going after some of the bigger fish. Yep. Sorry. 5 million. Let me. I think it's each. I think it's each because they have to keep bringing the suits. But I mean, the numbers vary depending on the size. But they've done out the math, is what I'm saying. I can give you the paper this one's based on if you want more depressing stuff to read. Right. Exactly. And so it's got nothing to do with whether you deserve to be sued. So the other thing that we've seen is like as you get further down, the economy has affected lawyers. In the late 90s and early aughts, law schools were saying like, hey, you should get a law degree because it's basically a ticket to being rich forever. And lots of 16-year-olds were like, yeah, that sounds like an awesome idea. I should start pre-law now, and I do want to be rich forever. And this is like kind of you see all these like fancy lawyers on TV, Cadillacs, champagne, caviar, etc. So lots and lots of people signed up for law school. And even by law firm standards, there are now too many lawyers. So, right. So what you see is firms that they're like, well, we can only take you on if you'll work on contingent fee. And one of the biggest growing areas we have for contingent fee lawyering is patents. And then you also see like small firms, like one or two people, probably friends from law school that still haven't found a real law school job. And they're like, oh, maybe we could do this contingent fee lawyering thing. And so you see it like all the way up and down the stack. So for like kind of the mid-size or larger ones, they'll go after a weaker defendant first. The goal is to establish a venue, maybe like East Texas, perhaps, or to get a little bit of money in the war chest, so they'll lowball the first couple, or to make the patent look more, robust. It's already been tried in court, and these other companies agreed to pay us, so it must be a good patent. It's yeah, sets some precedent. So for companies that are doing that, they go after weaker defendants first, and then try to move up the chain to larger and larger defendants. Um, Small firms will just go quantity over quality. They'll look at a company and be like, huh, if it's gonna cost you $2,000 to talk to your lawyer, we're gonna ask for like maybe 2,500. What do you think? And they're like, oh, jeez. I kind of hate meeting with that guy anyway. So yeah, all right, we'll do it. So they just send out letters, and they all, of course, say contingent on this is that you do not speak of this again. So you see, like all the way up and down, like from like very large companies and large law firms down to small patent holders and small like individual law offices bringing these kinds of suits on contingent. So what does that mean? Like, should we be raising more money to fight trolls or anti-competitive suits or that kind of thing? If you have the money, I say go for it. If you don't, uh, maybe you can borrow some defensive resources from larger community members. I do sometimes hear like, oh, no one will ever sue us because we don't have any money. That doesn't really work. Or that the patent system won't affect us because we don't have any money. But we all know that there are things that are not included in your regular default GNU Linux distribution because they're patent encumbered. So do people remember the anti-aliasing on the fonts? Yes. Okay. So yeah. So like you're like I'm excited. I'm gonna show my friend this new distro, and they're like, huh, what is it? And you're kind of like, it's sort of like Windows, but it's free, and the fonts are crufty. And they're like, oh, okay. It's just kind of like it's like a whole decade of like a not the best impression for free software. So, it's and there's I don't know if anyone ever got sued on the fonts or had to pay out any money, but the chilling effect of knowing that the anti-aliasing patent was out there meant like, well, we'll just skip it. It's not worth it. No one wants to get sued. Hmm. That's trademark, but yeah, that's how trademark works, but not patent. So yeah. Anyway, I don't want to confuse everyone. So lawyers and non-practicing entities or practicing sometimes not practicing other times entities have changed a lot. Judges and juries, we're going to look at that next. So in the 1990s, defendants in patent suits needed to find prior art or prove that their work was out of scope of the plaintiff's patent. So the courts were very reluctant to say it looks like the USPTO just granted a big pile of nothing there. They didn't really want to throw like a government agency under the bus. So if you wanted to fight on a patent suit, you had to either be like, oops, it looks like there was a piece of prior art that you missed. And so this wasn't actually novel when it was issued. Like, I understand why you thought it was, but okay. Or you had to say, oh, we're not actually doing the thing that the patent says. We're doing something slightly different. So that was the way that you would win a patent suit if in the 90s. And so most of the litigation would go down that way. And the courts were very reluctant to say the USPTO should not have issued that patent. This is the small bits of good news. That's changing. Today, you go up to, and this is before the America Invents Act was put in place in a couple of the more recent cases. So I think this is actually increasing, but the numbers we have are from 2008 and 2009. And I would love it if they would do a new version of this study. But at that time, you see 54% of suits are being won by the defendant via non-patentable subject matter. That means the court is saying that is a patent you should never have issued. That is a big pile of crap. I don't know what it's doing in my court, but we're not that patent should never have been issued, which is a huge change, right? So that's fantastic. Another thing that so then you see this like kind of reconfirmed at the Supreme Court level last year, which is awesome. This is the Alice versus CLS Bank ruling. This is like two financial entities that have their debits and credits managed by a third party. And this is something that's been probably going on since people were scratching their debts down on a rock with like a smoky stick or whatever. But because they were doing it on a computer, it had to go all the way to the Supreme Court in the current environment to be struck down. And the courts did say generic computer implementation is not patentable basically, if it's something you could do with a pencil and paper, and then you're just doing it on a computer, that is no longer enough to make it a patentable thing. That comes from the Supreme Court, and almost immediately in June that same year, this is a Federal Circuit case where they said the Supreme Court recently reaffirmed fundamental concepts by themselves are ineligible abstract ideas. And this is a case, Digitech. They had their patents were on data for displaying images on a screen. It was very like basic. And they went after anyone that had a screen, like phones, copiers, faxes, TVs, whatever. Maybe your reflection in the microwave, who knows? But like, if you had a screen, then they were going to send you a letter. And the Federal Circuit, I'm going to translate the legalese. This is basically like a fruit basket and a bottle of champagne. Thank you so much for allowing us to toss this pile of crap out of our courtroom. So that is basically what that says, which is fantastic. Another thing that we've been seeing on the rise, this was almost nothing in the 90s, and now you see indefiniteness, which is another way of saying, like, that patent didn't really say anything. I don't know what you're trying to protect here or what we're supposed to do with this, but we're not really going to uphold this. So we're seeing a rise in defendants winning on indefiniteness as well, which is also amazing. And this is basically been also reconfirmed at the Supreme Court level with the Nautilus versus BioSig ruling last year. Yeah, I know. Usually, until like last year, I had to always just give you guys 100% bad news in this topic. so I'm excited to be able to share something that's positive, right? For folks who don't know, this case was it's for when you do exercise and you put your hands on the little thing that reads your heartbeat or whatever. You can't patent the human hand. So they wanted a patent that was like on the design of this thing that is made to be the size of the human hand. So they decided they like threw all this verbiage on top of it to do everything they could to get like a patent on the human hand, but not saying the human hand, like as the size, because otherwise it's obvious, right? It's like, well, you use it with your hand, so it should be hand sized, right? And so they threw all this verbiage in there to be like, we have a patent on like vaguely, this shape, and and then it's to be used with like a human body part and stuff, So like and yeah. That's kind of TLDR, but that basically the Supreme Court also said like you can't enforce a super vague patent where nobody can figure out what it is you're trying to have a patent on, which is also awesome. We haven't seen as many of those upheld by the lower courts yet, but they have that tool in their box, and that's been used a little less. But we hope to see more cases. Yeah. Another thing that the courts have also been having this conversation. Most patent suits are heard by specific courts that are set up to hear patent suits. And does the conversation that's been happening is, does that create tunnel vision where you've politely they're saying like lost all perspective of what you're looking at, or is that like this great thing where you're specialized and you know your subject area really well and are more qualified to produce opinions on that matter? I think tunnel vision is like a really polite way of describing what's happening in East Texas, but I guess they have their own conferences, so they try to be polite to each other. Huh? Did I say West? I'm sorry. Yes, I don't. It is okay. Yeah. Anyway, so one of the things they're like, well, let's do this patent pilot program where we sometimes give other judges the opportunity to hear a patent suit, and just to kind of mix it up a little and maybe offer some counterbalance to the specialization or maybe tunnel vision, and so that's the way that it's been sort of promoted. What is interesting is so there hasn't been that many cases where the judges have given out a patent suit, but there have been a few. And what we found out is that more experience with patent suits makes judges less likely to rule for patent holders. So let's break that down. The numbers mean you get case number 1, and you meet the person who invented the internet. amazing. You tell your friends like, I met the guy who invented the internet at work to this week. It was awesome. He had a patent. Some people were trying to like, and so judges rule like they tend to rule the first time for the patent holder. It only takes a second case before they're like, wait a second, I met the guy who invented the internet last year. And then they're like, no, 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 no. So judges are starting to get a little bit more savvy about this. If we could only send the more cases randomly out to less specialized courts, then we might start to see more wins. Of course, the folks that bring the suits are always advocating to send them to the specialized courts because they know that they have a better chance there. So the moral of that story is that I think we finally met someone we liked when they're angry. So, which is good. And speaking of people we like when they're angry, this is also good news. The New York Attorney General Eric Schneiderman. Did people read about this? This is MPHJ. They had a ton of suits. Let me make sure. They had one patent that they brought in. These were scanner-related patents, and they just sent letters to everyone in New York that they thought might be using a scanner of some type. And the Attorney General ended up just bringing a suit and made them give back all the money. So, again, someone we like when they're angry. Fantastic. Also, and then with the same entity, MPHJ brought a bunch of suits in Vermont on not scanner-related patents, but distributed computer architecture and process for document management. It kind of sounds like Google Docs to me, but whatever. Anyway, so they brought a bunch of suits, including one against a large nonprofit in Vermont that serves people with disabilities. And the Vermont AG was like, "Are you kidding me? Like, get out of my court." So they ended up suing them for violating the Vermont Consumer Protection Act. So we are starting to see some judges that are pushing back and are like, I do not want to be your puppet for this ridiculous game that you insist on playing with the legal system. So, hooray, right? That's 2 states out of 50. Right. So, and then also juries are another story altogether. Juries have not changed that much, which is too bad because they don't get to have the repeat thing where they meet the person who invented the mobile phone every week. They rule more often for the patent holder. There are also some things specific, like juries tend to have more folks that are retired and are cited about free lunch and stuff, and and the particular district in East Texas is it's farmers. It's like it's older people that really no part of their business has been technology. So judges tend to rule for the patentee only about half the time, and that number may be improving. But juries tend to rule for the patentee over 2/3 of the time, and that numbers remain more constant. The bad news, again, we can only have so much good news apparently on this topic, is that over 70% of patent cases are heard by juries today. And that number, about 20 years ago, was closer to 5%. So again, we know that the legal representation for the plaintiff is very much aware of this. They always push to get a jury trial if they can. So, and like everything about the court system favors the frequent litigator. If you go in there week after week, you know the judges, you know how to, get the jury eaten out of your hand, you know how to play the game with regard to the forum shopping, all of these types of things. So, that's not working. But there are some things that are working. A couple more spots. Germany, New Zealand, and India have put strict limits on patentability, so not every single jurisdiction is going down the toilet on this, which is great. Yeah, I didn't know that. I have a colleague in India, and he's like, yeah, we're also not accepting. I mean, and they're not saying no to like all software suits. Most of them have like some loopholes for software and hardware in combination. But pure software is supposed to be outside the scope of patentability in these jurisdictions. If you want to read the legislation, like again, this is not legal advice. Don't go move to Germany because I told you they don't have software patents there. Um, so that means sometimes democracy works, which is pretty fantastic, but not always, and not in larger places. So New Zealand in particular, I had the opportunity to meet some of the folks who worked on the legislation there to put software patents outside the scope of patentability, and they said, well, honestly, New Zealand's kind of hippie and it's pretty small, and we have pretty good access to our legislators. So, yeah. And then, of course, there were the next week I was in Melbourne and I was talking to the Australian folks. I'm like, how likely are you guys to do something like they did in New Zealand? They're like, no. It's not going to happen. Australia's much bigger. And the U.S., like we know that the money and politics problem is also a huge factor. So when you have people who are invested in the current situation with regards to patents, and you have lobbying against any kind of reform that doesn't specifically hit the problem of trolls. So there are a lot of practicing entities that are very wary of patent reform stepping over the line from just getting rid of trolls to doing anything else at all. Every single company that thinks they have skin in that game has their own in-house counsel that has a different idea of where that line is, right? So sometimes it works and sometimes it doesn't. But smaller places, it tends to work a little bit better. So the EFF is working on legislation that would do this nationally. I don't know if with the current Congress any of that's going to happen, but but at the state level, we have been able to. A lot of states have been able to pass legislation saying there has to be some more transparency around patent suits. So you have to disclose the real party and interest. So if you set up a shell company just to bring patent suits for you, you have to say that you're sending all the money back up to the parent company. You have to say the actual patent you're suing on. And then you have to say what the actual activity that the defendant is engaging in that you think is is the infringing activity. So weirdly enough, you didn't have to say any of that before, and you still don't have to say it in all of the states that are still blank. You'll notice that Texas, Delaware, California, and Massachusetts have not passed any such legislation. Yeah. Um. Oh. There's not currently a green. They've updated this a couple of times, so there probably was a green one at some point, or it could be. Yeah. Yeah, and so they'll update this again. If you know something about one of these states that's not accurate, I would encourage you to contact Patent Progress because I think they'd like to have it be up to date if it's not. But I think there just isn't currently anyone in the green category. I'll totally make the slides available for you guys online. Yeah. You go ahead and tell them that. So, other things that are working, the American Invents Act, which went into effect in 2012, no more joinder. Joinder is a fancy legal term, meaning you send out a letter to 17 different companies at once instead of sending out 17 individual letters. Why we thought it would be nice to let patent trolls save on postage, I don't know, but we switched that in AIA. It's like the reverse. It's like where you sue a bunch of people at once instead of suing them all individually. And you can't do that. So you see here, it went down the number of distinctly separate lawsuits, and then they figured out how to buy more stamps and kind of went. Maybe. Well, it's illegal now. You can't do it because AI. And then I work at the Open Invention Network. We offer a mutual non-aggression pact just for the free and open source software community. It covers Linux, GNU, Android, and a ton of development tools. Basically, it's about 1,200 SLAS companies that have agreed to not sue each other. So that's pretty awesome. We also offer a cross license. Everyone offers a cross license on their patents to everyone else in the pool. So if you get sued from outside the community, you have something to countersue with. So if it's an actual practicing entity that you get sued by, you can send them a letter back like, oh, well, I have a bunch of things that I'd like to talk to you about, and hopefully they'll go away. Um, no guarantees. Still, better than nothing. We also coordinate a lot of defensive publishing, which is instead of adding more patents to the pile, it's saying like, I invented a thing and I would like everyone to know about it and no one to have a patent on it, and we'll help you write that if you want. And that's it's like creating prior art that blocks patents that haven't been issued yet. And I have a colleague who focuses out on that specifically. So if that sounds like a thing, you're like, we've invented stuff that we didn't want to patent, but we didn't want to have other people have patents on. I can help you with that. I don't know about a 1 year time frame. Again, this is my colleague Andrea specializes on this, so if there is such a thing, I'm not aware of it, but she definitely does know that there was a 1 year. Yeah, I think, and it's that doesn't totally surprise me. So the earlier you do it, the better, anyway. So and it is not enough to just have it like on the internet or on a repository somewhere, especially given how well documented all software is, right? Um, anyway, so your homework. If you want to participate in patent busting, which is a fun activity for smart people that have a good sense of what the current state of the art is, we coordinate the Linux Defenders one, which is specifically around the operating system stuff. Trolling Effects is the EFF one where you can patent bust with them, and then Stack Exchange is a more general technology one, not specific to free and open source software. And some of them it's really easy. It's a matter of knowing where the prior art is. Like I saw one, I think it might have been here, whereas Microsoft wanted a patent on the amazing invention by which you put the word attachment in your email and then you forget to put the attachment on, and a little box comes up and says, "Did you forget to put your attachment?" So some of them would be pretty easy to knock out if you can get past the eye bleeding legalese. And it's worth doing, and you would be doing a fantastic service to the community. These are in process. So these are ones that are in the application. So this would be like as blocking a current application. But for the warm fuzzy glow of doing something for the community, there could eventually be cookies. Um, well, yeah, that is my secret goal is to better humanity. If you have not met me before, then you might not have known that, but that is part of my secret goal. Yes. What type? I'm sorry. Say that again. Oh, are you? So you want to know what type of patents the FOSS community likes? This, is there anything the FOSS community agrees on 100% as a whole? I'm not. Yeah. So yeah. Yes. Yes. Okay. Uh, beer is awesome and software should be free. There are different companies have different perspectives on that, and some feel like whatever. It's yeah. I mean, we don't really police the border of who gets to call themselves a FOSS company, so like it's that one's too long. I think we'll have to talk about it in the hall afterwards. Oh, for defensive purposes only. Yes, I would agree with that. That if we're going to compete with proprietary companies that have tons and tons of patents, then we should have them and use them defensively. And we should share them amongst the entire community, which is one of the things we coordinated at OIN. That would be the long-term goal. But until we can make the U.S. more like New Zealand, it's gonna take a while. And I'm not opposed. New Zealand was awesome. So pass laws if you can. If you live in a jurisdiction or a state that was blank there, that would be awesome. The process is not as straightforward as you might think. Before I came to free software, I used to work on political advocacy and trying to pass legislation for working families, like minimum wage and that kind of thing. Man, if you like the sausage analogy for making laws, completely true. So, but again, amazing work if you decide to take it up. Um, Keep talking to your neighbors and colleagues. Part of the problem and why we're not, I think, entirely ready for like sweeping reform is because sort of the popular idea around what's happening with software patents is like, who cares if Samsung and Apple sue each other? Those two companies have so much money that like I don't care if they decide to trade it back and forth every year, whatever. So like the average person that's not working for one of those companies or working in technology and understanding how that works out as far as like what we get to include in our distributions and all of those types of things are just like, yeah, two ridiculously rich white guys like beating each other up in court. I don't care. So whatever you can do to change that perception and make it more real for neighbors and colleagues that might not have someone else in their life that understands how that makes your phone more expensive if you have to pull that card out, but also makes your life annoying because you have to code around things or not include stuff in your work. Let them know so that we can eventually get to that place where everyone's like, yeah, those things are dumb. Let's get rid of them. So, because I mean, it's great. This is a full room at the end of the day on Sunday, but I don't think we're going to be able to do it alone. So, if you like reading about this stuff, I have several things that you could take a look at. The top one is the only one I was able to get any numbers on what's happening in Europe. If you see another paper, let me know. The patent litigation could, and this is sort of a super theoretical exercise on like what might happen if we just reduce the term for patents. The contingent fee representation one, if you want to, like you don't have enough villains in your current reading. Speaking of villains, does familiarity breed contempt among judges deciding patent cases? As we know, the answer is yeah, kind of. And then the things about the indefiniteness and basically how the courts began to embrace saying the USPTO is full of crap. That is all in that last one. And then there's also tons of stuff at lens.org. Again, I'll make these available online. Those are all the picture credits. It can't be a talk on legal issues without all the licenses, of course. And then I would be happy to take your questions. Thank you. All right. Here, and then I'll go in the back. Something about the requirement for establishing prior art. So, you basically have to have something that you think is novel. Yeah, that hasn't been done before. And it's you just have to describe it with some good specificity to make it defensible. But again, my colleague Andrea would be happy to talk to you about your specific ideas for prior art and get your stuff to that level. No, no, no. The USPTO does not troll GitHub all the time to look for this current state of the art. Even if they did, none of it's documented, or almost none of it's documented. They wouldn't know what they were looking at. So, Robinson and then John. Yeah. Right. Right. So, yeah, the scope of patentability is all federal. You cannot just say we don't have software patents in our state. The question is about local legislation, but you can make some changes about what is kind of the default process for bringing a suit. So all that statewide legislation was about transparency, disclosing the real party and interest, saying the exact patent that you're suing on, and saying what you think the defendant is doing that infringes on your patent. So you can change like kind of like what's the process and how it's done, but you can't change the scope of patentability at the state level. John, and then up here. Uh huh. Mm. Mhm. Oh man. Yeah. Mm. Oh man. Oh no, and that's what I'm saying is I think it's very important to make that narrative known. So just paraphrasing for the recording, the cost of the system impacts small companies and organizations like the FSF who have been subpoenaed to produce prior art for other people's patent suits. Um, were you able to bill yourself as an expert witness? Oh, right. It's not. Oh no. Well, yeah, I'm not sure if that would be possible. I was just wondering. Awesome. So, for folks who didn't get that on the recording, one particular deposition where you were called to by one party to help invalidate their competitor's patent, you were able to also invalidate the plaintiff's patent. That's fantastic. That's awesome. Over here and then over here. Yeah. Right, so it has to be within that time range. You would have to do it before. That's why you file. So defensive publishing in file. So the question is first to file versus first to invent. And the America Invents Act actually puts America in the same category as many other Western patent regimes, insofar as we now also have first to file instead of first to invent. So that means that it's even more critical to sort of file and not just invent. Yeah. Well, I mean, it's kind of. I mean, you can still produce prior art, but it's slightly more stringent. It's better to file is the upshot. Yeah. Oh, so the question is there an organization that we could create to fight software patents as a group? And in fact, the Free Software Foundation does have, they have an End Software Patents campaign that is slightly separate from their other issues in order to let people participate, whether if they don't agree with everything else that the FSF is working on, but they at least agree on the software patents part, they're able to work on that campaign. So, and there's a wiki. Is it End Software Patents or what's the URL for the End Software Patents campaign? Endsoftpatents.org. Yeah. And then one right here.
So there's a lot of engineering companies that have both hardware and software engineers that
Uh-huh.
It's heavily promoted to file patents.
Yeah.
And so they believe it's in their interest, and they have
Yeah.
provable data that says it's in their interest. So if you're a software engineer in those companies and you feel the same way that maybe we shouldn't have software patents, at
Mhm.
least from my personal perspective, I haven't seen any good arguments to bring to the management of that company why it's not that's something that's sorely lacking.
So the question is, how do you manage up? Or I don't know if this part's getting recorded because of the microphone. How do you, as an engineer, talk to your management about not producing patents? And I saw your hand shoot up. Did you want to speak specifically to that?
Specific example. Okay, so I have a friend that works at a company that might have had problems with a larger company suing them. So the thing was get defensive patents so that you have something to sue back with. With the new first to file, the smaller company can now, instead of having to file patents, because the smaller company's patents money for filing patents is far less than the larger company. The larger company can basically keep hitting them with lawyers all day long and not feel it because of the size differential. But by being able to file things and basically publish them and say, we've got this, then they've got this. The smaller company is now getting that patent protection by being able to put things out without having to spend the 25 or 50 grand a pop to go through and file the patent. So it depends on the size of your company and how much the patents are important to the business model. But especially for small companies, for startups, filing patents is freaking expensive.
Well, that's what I said. The premise of my question was, you work at a larger company.
Okay, I missed the larger, sorry.
File patents.
Yeah.
So people put on their resume, I am responsible for 3 or 4 or 5 patents. The more you have, the more prestige you get. Ergo,
Yeah.
question.
Okay.
There's nothing to push back on that I'm aware of.
Well, you can put defensive publications on your resume also, and and again, it's you could put them there. It's the first couple of people that do that instead of putting an actual patent on there is going to be like, I don't know if that's as good. But the more that you do it, the more I think the more acceptable and that's going to be. It's still work that you did. It's still work you created. So that would be my thing. It's my advice on that particular one. But there are definitely for whichever company you're asking about, your friend's company or just in general. So there are companies that don't encourage a lot of patenting like that, and what patents they do have are for defensive purposes only. You could perhaps try and get your company to talk to someone in similar place within the management chain, at like say Red Hat or somewhere else where they are not doing the monetizing the patents. They have a few for defense, and they're not like constantly pushing folks to patent all the time. So. Or you could not work for jerks. I'm repeating that so it's recorded, but yeah, I mean it's going to take a long time, I think, because it is an escalation of defense of offensive weaponry.
Right. I was just going to. I mean, some people are going to view that as unilateral disarmament. Look, I worked for a company where I had to work with my corporate lawyers to work against the SCoLE patent. We were one of the people that were issued the letters. We had to do that work. I mean, that was a royal pain in the ass, and it wasn't. You can look at it in hindsight. It wasn't at all decisive from the get-go.
Right. No, and I think it's going to take a long time, and I would encourage everyone in this room who is an engineer to continue to push back in the legal department, because if you let lawyers set the tone and the direction for your company, then you're going to end up with more jobs for people to write more patents in your company, because that's what is interesting to them. Yeah.
So I have just a thought suggestion on that. We can look at the situation that's happening right now. Here's one example. I was at a big conference with a bunch of tech people, and everybody hated on all of the companies that had patents, and the ones that were being just defensive got all of this great press and PR, and the public liked all of that. And the Supreme Court, just said this thing about the Alice thing. And so if we have patents that are bullshit, then eventually this is going to come back to bite us, because sometime this is going to be in the public and people are going to be mocking this company and being very bad PR for how bad this patent is. And so you can argue that we shouldn't patent something that you can make a serious case that it's a very bad patent that shouldn't be patented. but that doesn't answer a situation in which maybe the patent
I think there
wouldn't
is
be
not, unfortunately, there's not a silver bullet. And I had one question up here too, if you don't mind, Sean.
So I had a question. In the press, there was a big case with a certain company, SCO, which doesn't exist anymore, except for the trolls who were using that company to sue over patents.
Right.
And I'm looking at this patent going, I know this is completely ridiculous because I worked at that company and I know what was what at that time.
Right.
Perhaps even I might have evidence somewhere in my storage unit that this is the case. But I was sitting there thinking, assuming I even found this evidence, where would I send that? Because personally I'm thinking this is the stupidest thing I've ever heard of, and it shouldn't even be in the press, and it shouldn't even be happening. So what can I do? And anybody who's been in the industry for a while may be in this exact situation of saying, hey, I have the evidence that shows that this is bogus.
If you know of a defendant that's being sued with a bogus patent that you have prior art on, then I would say contact that defendant. Maybe get them to pay you as an expert witness.
All right, I
Just saying. Everyone's got to eat. So, all right. It seems like folks are ready to, talk amongst themselves on this, which is fantastic. Thank you for staying to the very end of SCaLE, one of my favorite conferences ever. Thank you.